Good afternoon, everyone. It's a pleasure to have you here again in our illicit trade lunch seminar. Welcome Ratna Juwita as our speaker for the day. She is a PhD student at the Faculty of Law here in Groningen, but she's done also she's graduated from I need to make sure I do correctly pronounce the name, Atma Yatna Yogyakarta University. And she started her PhD in 2019 here in Groningen. She is an expert in corruption, and she's going to present today a part of her work and her research on how corruption affects human rights practices. It's a pleasure for me to have you today here, Ratna. So without further ado, I will leave you the time for your presentation. Then we're going to have also time for Q&A. Again, it's a pleasure to have you, and the floor is yours. Thank you, Ratna.
Okay, thank you very much for your kind introduction, Francesco. I will start my presentation. I will share my screen. This one. Can you guys see the screen?
Yes, it's
okay. Yeah, I'll start my stopwatch. Okay. Yeah. So today I would like to present a part of my research, part of my PhD. The title is Exploring Corruption as a Violation of Human Rights in the Practices of International Human Rights Institutions. My name is Ratna Juwita. You can call me Ratna. And so the motivation behind the study. So corruption is a very difficult problem because once it becomes systemic, it will be very hard to be eradicated. I started my presentation with two quotes from the Transparency International and Kofi Annan on how they try to link corruption and human rights. So corruption enables both human rights abuses and democratic decline. In turn, these factors lead to higher levels of corruption and setting off a vicious cycle. So when corruption becomes cycle, it is very difficult to break it. That's why the UNCAC, the United Nations Convention Against Corruption, even mandated that a country must establish a particular independent anti-corruption body, because the regular executive, judicative, legislative, they are not enough to combat corruption. That's why you need a special body with special power to combat corruption. And Kofi Annan, he stated that corruption is an insidious plague that has a wide range of corrosive effects on societies. It undermines democracy and the rule of law, and it leads to violation of human rights. So when he said that it leads to a violation of human rights, then it's his part, and our part is try to argue how it leads to a violation of human rights in a legal sense, not just as a figure of speech. Because at the moment, what we have is mostly the idea that corruption might violate human rights, but more as a figure of speech instead of a strong legal concept that can really protect the people. So I would like to introduce you to the roadmap of my PhD research before we go into the specific article. So the first layer of my PhD research is I would like to see what kind of corruption exists in Indonesia, especially in health and education sectors. Because if I would like to argue that corruption amounts to a violation of human rights, I have to specify which type of corruption that can be argued it really has the link towards human rights violation. And then the second is on the analysis of the practices of international human rights institutions and domestic practice in Indonesia, which I will share with you on the international human rights institution practices. And the last is on the transformation of an emerging norm into a legal norm by norm entrepreneurs, guided by interactional legal theory. Because I think it is very important for us to map the phase of the norm development from this emerging norm proposed by norm entrepreneurs into a legal norm. What can they do? What should they do? And then this is a brief introduction of my findings about Indonesia. So as a human rights scholar, I believe that human rights starts from home. If it's not existed in your home, then it's not existed at all. So I think it's a good mindset to believe that we have to study the situation of our home country before we try to study the situation of other country. The reason why many scholars interested to argue that corruption amounts to a violation of human rights is because of the negative impacts of corruption towards the protection and realization of the rights. From the example of Indonesia, I found that there are three types of health and education sector corruption. The first is grand corruption in the procurement projects. So in one of the cases that I found, corruption happened in the procurement of ventilators. So during the procurement projects, the companies, they came directly to the ex-minister of health and made the arrangement, and the minister got bribed by the company, and the result is, take for example, we could have bought 15 ventilators, but we could only buy 5 or 10. And I look at I look in the context of COVID situation, one ventilator can really make a difference towards someone's life. And it's a pity that corruption happened and Indonesia could have bought more ventilators, but Indonesia could not, while Indonesia has the money to do so. So that's the example of how corruption impacts the realization of the right to health. And then the second is the obstruction of the justice process. So I found the cases where corruptors were investigated and charged and prosecuted, but during this process, they tried to, bribe the judges, they tried to bribe the prosecutors, and these law officials, they agreed to be bribed. Thankfully, Corruption Eradication Commission intervened and brought the process back to the ideal process. But you can imagine, if the Corruption Eradication Commission did not intervene, then there would be impunity. And more impunity will breed the culture of corruption that set off the vicious cycle of corruption. And then the third is corruption in the decentralization. The pattern is a bit similar with the first type of corruption, but the corruption in decentralization has different underlying motive. From the cases that I read, the reason why mayors, regions, governors, they committed corruption is to gain a certain amount of money to fund their next election. So this is also setting the next vicious cycle of corruption. Indonesia will never be able to get the correct public official with merits when they funded their campaign due to with corrupt money. And then the other reason why human rights is a promising solution towards anti-corruption strategies is because incorporating human rights into anti-corruption strategies will hopefully help complement the current criminal law measures towards anti-corruption. So the example is the amendment of the anti-corruption law in Indonesia in 2019. So the amendment tries to bring more human rights provisions into the current law because the previous law, they don't have enough protection on habeas corpus and also the provision on wiretapping. It was a bit loose. And then the Indonesian legislators, they tried to put, protection of presumption of innocence towards that because in the past, the corruptors, they always try to twist this presumption of innocence into their benefit. So it was difficult for the Corruption Eradication Commission to wiretap people as effectively as possible because eventually during the court process, the corruptors will always argue that this wiretapping, it was conducted by the means of violation of presumption of innocence, and the case was dropped. So it was everything was not an easy task to incorporate human rights into anti-corruption strategies, but I believe it's still promising to do so. And then how to argue whether corruption amounts to a violation of human rights? One of the way we have to look for the practices of international human rights institution, whether there is an evolution in the way the international human rights institution clarify, connect, and build reasoning on corruption as a violation of human rights. So the starting point of this research is Boersma's research in 2012. So Boersma, she made a dissertation on corruption as a violation of human rights and a crime under international law, which one of her chapter discussed the compilation of international human rights institution normative outputs on corruption as a violation of human rights. So she collected the normative outputs of the international human rights institution from 1994 to 2012 to see how the international human rights institution clarify and connect the link between corruption and human rights. So the international human rights institutions in this research, I categorize that into two. The first is the charter-based. We have the Human Rights Council, special rapporteurs, independent experts, and working groups. And the treaty-based, we have Human Rights Committee, Committee on Economic, Social, and Cultural Rights, Committee on the Rights of the Child, Committee on the Elimination of All Forms of Discrimination Against Women, Committee on the Elimination of All Forms of Racial Discrimination, Committee Against Torture, Committee on the Protection of All Rights of Migrant Workers, and lastly, Committee on the Protection of All Persons with Disabilities. So the methodology that I employed, it's the same like Boersma's methodology because the aim of this research is to really compare whether there is an evolution between what Boersma found and what I found. So we use two online databases. The first is from the Universal Human Rights Index for the state reporting procedures. And the second is from the URIS Office of the High Commissioner on Human Rights for the individual communications. And the keywords that I employed is corrupt asterisk, brave asterisk, embezzle asterisk, and misappropriate asterisk. And the time limit is from 2012 to 2019. So the keyword that has most findings is the corrupt asterisk with 879 recommendations. And the keyword with the least findings is embezzle asterisk with only 4 recommendations. And for the jurisprudence, we have 97 results found with those keywords. So I define the evolution in this research is the first, there must be an increase in quantitative documents, the number of the normative outputs that mention the keywords. The second, there must be an increase in qualitative content. The content must be richer and more specific that mention the keywords. And comparing it to the Boersma's findings, because she predicted that in the future, the international human rights institutions will increase attention on corruption and human rights. So as we can see, the figures, the quantitative evolution of the normative outputs. The first block is the Boersma's findings from 1994 to 2012. And the second one is my findings. And you can see the blue one is the special rapporteur normative outputs. The orange one is the independent experts. And the gray one is from the working groups. There is a significant increase in numbers. And in Boersma's findings, the working groups, they were non-existent, the documents from them. And I'm sorry that this font is very small, but I tried to really put the information in details in this slide. So you can see the number of the normative outputs and the number of the actors are increased. But caution must be made that the increase of actors and normative outputs, there might be a special procedure that ceased to exist and new special procedures that were established. But still, regardless of that, based on the comparison between periods, the increase of actors and normative outputs are significant. And in the concluding observations from the Universal Periodic Reviews by the Human Rights Council, we can see that there is also an increase. In 1994 to 2012, there were only 77 documents, and in 2012 to 2019, there are 116 documents. And this is the findings on the treaty-based bodies. As we can see from the bodies and the findings from BURSMA and my findings, we can see that there is also an increase, but there is also a decrease from the Committee on the Elimination of Racial Discrimination. But still, I believe that there is an increase in normative outputs from the treaty-based bodies. And the qualitative evolution of the International Human Rights Institution normative outputs, I tried to categorize the recurring themes that appear in the normative outputs, and I found that there are 5. The first is the need to address the root causes of corruption, which were mentioned 7 times in the data collection. And then the negative impacts of corruption. So the international human rights institutions, they went into a more specific aspect. The first is on the budget allocation, and the second is on the health and education sectors. The negative impacts of corruption on budget allocation was mentioned 7 times. The negative impacts of corruption on health and education sectors was mentioned 12 times. And the third is the impunity due to judicial failure and corruption in the judiciary. This was the most mentioned because 183 documents mention that there is a need for the state party to pay into consideration the harm of corruption in these forms. And then there is the need to include civil society and whistleblower protection. This is basic in combating corruption. It was being mentioned in 9 documents. And the 5th theme is the need for the state party to combat tax evasion and money laundering. These 2 are the manifestation of corruption. And in BURSMA's findings, the International Human Rights Institution, they did not mention tax evasion and money laundering. But in 2012 up to 2019 period, the International Human Rights Institution started to bring these 2 crimes into light. And I think this is an evolution, because when you are trying to be more specific with the manifestation of corruption, it means that you are one step away to combat it. So I believe that in the future this must be mentioned more. And then I analyzed it further, the findings, into 2 categories. The first is the progress and the stagnations from the findings. As we can see from the concluding observations, there is a progress. There is a richer content on corruption and how it relates to the protection and realization of human rights. I have one example from the Human Rights Committee. So the Human Rights Committee stated that systemic corruption can lead to a violation of covenant provision. So even though the Human Rights Committee did not explain further how it's going to lead to the violation of the covenant provision, I think it is still a development, because in the past the recommendations are very vague and general, saying that the state party must take into attention the situation of corruption. That's all. But when it gets richer in context, I think that the Human Rights Committee are trying to persuade the state country to see how corruption linked to the realization of human rights. And then this is the recommendation from the Committee on Economic, Social and Cultural Rights that stated corruption has a devastating impact on the enjoyment of economic, social and cultural rights, particularly by disadvantaged and marginalized individuals and groups. So in the past, the international human rights institution tend to use the word negative. And in recent normative documents, they try to select words that best describe how corruption impacts the realization of human rights. And I think the word devastating portrays it better, because we are legal scholars. We believe that the more we can find the word that explain the situation, the better it is for us to establish the link between corruption and violation of human rights. So the international human rights mechanism have the potential to clarify the link between corruption and human rights because it's their mandate. However, there is no clear statement from the international human rights institution that corruption amounts to a violation of human rights from the state reporting procedure. So the closest interpretation that we have is corruption is a systemic problem that leads to a violation of human rights. And the other observations, they are basic on how that corruption poses harm to the realization of human rights. And then we come to the stagnation on individual communication trajectory. So in the international human rights system, we have the individual communication trajectory, where an individual can submit complaints against their government towards the committee. And there are many decisions found through the keywords filter 97, but there is no decision that clarified the relationship between corruption and human rights. So corruption is considered as a contributing factor in human rights violation cases, but the international human rights institutions do not conduct further investigation on the link between corruption and actual violations of the particular rights. So I will explain to you several cases that I found. So in these cases, most of the cases, the Human Rights Committee stated that there is a violation of human rights, but corruption was not being taken into consideration further on whether this corruption is the primary factor why the violation happened. So the first is the case of HEAK versus Denmark. So it's the case of deportation of the author to Egypt, and the author argued that if Denmark returned him to Egypt, then it would bring him to the risk of torture. And he explained that the reason why is because the club that he founded was participated in anti-corruption protests, and then the government designated the club as a terrorist group. The Human Rights Committee found that there is a violation of Article 7, but the Human Rights Committee did not take further the corruption, the facts of corruption that was brought by the complainant. And then there is this case of Ivan Kruk versus Belarus. So the author argued that he was charged with an administrative offense by the government because of his anti-corruption stance. And he further claimed that there was a politically motivated surveillance due to his stand against corruption. So again, the Human Rights Committee found that there is a violation of Article 19, paragraph 2 of ICCPR, freedom of expression, but the Human Rights Committee did not take further that the anti-corruption stance of the author that became the reason why everything happened towards him. And then there is this case of Zoya Kolodova versus Russia. So the complainant's son, he was murdered because of his work as a journalist in reporting the irregularities, including corruption in the army. So the author argued that this activity was the primary reason why the complainant's son was murdered. But the Human Rights Committee, even though they found that there is a violation of Article 2, Paragraph 3A and Article 6, Paragraph 1 on effective remedy and right to life, they did not take into consideration so much that the anti-corruption stance of this complainant's son. And then this is an interesting case on OK versus Latvia, that the complaint was based on the lack of observation concerning the death of the author's son that the complainant claimed that it was a result of widespread corruption in Latvia, which contributed as a factor to the lack of observation and investigation of the death of her son. And the case domestically, it was closed due to the statutory limitation. She and her daughter tried to find justice through the Human Rights Committee procedures, but the Human Rights Committee declared that the case inadmissible and did not consider the allegation of corruption because the complainant could not substantiate and provide evidence of police corruption in Latvia. I will explain this case further after I finish the rest of the cases. There is also this case of Lydia Chacho Ribeiro versus Mexico. So the complainant published a book that revealed the existence of corruption and child exploitation ring, and she exposed various public authorities and also a powerful businessman. And the result of her activities, she was kidnapped and she was tortured. So the Human Rights Committee found that there is a violation of Article 7 towards her, but the Human Rights Committee did not take into consideration that her activities that expose corruption is the primary reason why such misery happened to her. And then the last is the case of Osai Omo Amenakhawan versus Denmark. So the complainant is a victim of human rights trafficking in Nigeria, and she argued that she must not be deported because bribery is a common practice in Nigeria. Therefore, if she were returned, then the Nigerian government would not have the power to protect her because her human traffickers could always find a way to bribe the government and then try to catch her. And the Human Rights Committee found that there is a violation of Article 6 and Article 7. But the problem that I see is the Human Rights Committee missed the chance to critically address the complainant's argument about corruption in Nigeria that caused the Nigerian government's inability to protect her. I believe that the Human Rights Committee could have linked this argument with the decision not to deport, because eventually the Human Rights Committee found that there is a violation. Why not analyzing the reason why violation happened? So I think that in case the particular country has good anti-corruption mechanism and the corruption it was low, there might not be a possibility for human traffickers to be able to bribe and eventually to catch her. So Denmark could easily return her to Nigeria in case Nigeria is free from corruption. So I believe that it's important for the Human Rights Committee to try to see that corruption could also be the primary factor why violation happened in the first place. So most findings from the Human Rights Committee and Committee Against Torture show that challenging corruption via this method of adjudication, it's difficult because the complainant has to obtain convincing evidence of the government's corruption, like in the case of OK versus Latvia. So the authority and capacity to investigate corruption belongs to the state, and an individual, take for example in the case of OK versus Latvia, a housewife, how could she have the authority and power to obtain sufficient strong evidence of police corruption in Latvia? Even in Indonesia, anti-corruption commission, such a strong body, strong resources, sometimes they found it difficult to obtain sufficient evidence of corruption. Therefore, this situation explains why the decision that specifically analyzes the link between corruption and human rights, or even argue that corruption is a violation of human rights, is rare or even non-existent, because the limitation of the individual to obtain evidence of corruption. So we come to the conclusion and recommendation. So I believe that there is a quantitative evolution that can be proven by the increase of the normative outputs, and also there is a qualitative evolution that can be proven by the richer context and recommendations based on the reporting mechanisms. So both quantitative and qualitative evolution constitute as a progress to clarify further the link between corruption and human rights, and possibly to formulate corruption as a violation of human rights, which I believe is the next stage of the evolution. And then the stagnation comes from the individual communication mechanism because of the reason that I have explained before, but I still believe that both mechanisms have potentials to evolve the link and concept further. The recommendation for the international human rights institution, the international human rights institution should take into consideration the gravity of corruption in each case and link it with the violation of human rights in question. Like I explained before, I think it's important for the Human Rights Committee to imagine if the particular country doesn't have problem with corruption, would the human rights violation happen in the first place? So like in the case of OK versus Latvia, Osai Amenakhawon and Lydia Kako, the reason why they complained that they were being kidnapped, they were victim of human rights trafficking, is because corruption enables the whole process to happen. And when the Human Rights Committee can recognize this, the benefit is the first, corruption can be acknowledged as a contributing factor of human rights violation, and the second, the Human Rights Committee has the chance to recommend the country to increase its effort in combating corruption. And I think this is important to bring corruption into the light this way. And then there is a need to include anti-corruption academics and activists into the mechanisms to enrich the quality of recommendations. So usually the recommendations from the international human rights institutions, they are vague and general, as if they are being given in a similar manner towards every state party. Well, I believe that corruption, it's different from one country to another. It depends on the history, it depends on the culture, it depends on the economic development. It's like cancer. So every cancer has their own different symptoms. And to cure cancers, you have to find specific treatments. So I think it's very important to include anti-corruption academic and activists because they have done a lot of studies, specific studies towards particular type of corruption. And human rights institutions can benefit from their expertise to provide concrete recommendations. So the state party doesn't have to think for itself, like what kind of concrete actions that I have to take to eradicate corruption and at the same time protect and realize human rights. So concrete recommendation can also bring better assessment of the state parties in 4 years later. If you give concrete recommendations, it means that you can assess it also in a concrete manner. You can also set the goals, and also you can find what is hampering these goals from the reality. So I suggest that the individual communication trajectory must follow the reporting mechanism trajectory in clarifying the link between corruption and human rights. I know these two are different, but I think that the individual communication mechanism must take into consideration that allegation of corruption, the complainant might not have sufficient power to obtain such a strong evidence. Therefore, when the complainant brought the argument on corruption, it should be taken into consideration and not simply dismissed because the complainant doesn't have enough evidence on it. And then the recommendation for the academic and activists on both fields. So the research shown that it specifies on the causes and consequences of corruption. So both academic and activists in those fields must conduct research on the causes of corruption, the root causes of corruption, and the consequences of corruption, the negative impact of corruption on budget allocation, health and education sectors, impunity due to judicial failure and corruption in judiciary, the need to include society, improve whistleblower protection, tax evasion, and money laundering. Because in the future, these 5 themes will continue to recur in the normative outputs. And lastly, it is important to continue research on the evolution of the normative outputs. So this is more like a longitudinal study on how in every 5 or 10 years you try to see whether there is an increase or worse, there is a decrease in the study of these 2 topics. So that's the end of my presentation. Thank you very much for your kind attention, and I give the floor back to Francesco.
Ratna, thank you very much for this very deep and intense but very also important presentation on a subject that is very central to what we do. Corruption is somehow related to a number of illicit activities. And again, we want to stress that we think about illicit activities precisely to cover the set of practices beyond the illegal and the legal, also covering the informal. There is something there happening, and corruption is certainly a very important link that connects the illicit and illicit practices. So thank you very much for your presentation.